This is a talk for the European Civil Law Observatory on the impact of Regulation 864/2007, commonly known as Rome II, on the applicable law in the case of non-contractual obligations. As a little bit of context, it's given by me, McDermott QC. I'm a Queen's Counsel specialising in catastrophic injuries, so that many of my clients suffer very serious injury, whether to the spinal cord or brain injury, both in England and Wales and further afield, and particularly in the European Union in this context. But what I say is applicable to tortious liabilities generally, and much of the case law will be developed across the whole range of tortious liabilities, although it seems to me that the case law that arises out of road traffic accidents in particular that happen within different jurisdictions in the European Union may give rise to very much of the jurisprudence that affects the application and the interpretation of this regulation as we move forward with it. I'm going to deal with the regulation itself. I'm going to mention the case of Homowu in the European Court, and I'm also going to deal a little bit with the way in which foreign law issues are handled by domestic courts, certainly in England and Wales. As a little bit of background, conflicts of law in England has undergone quite a change in the last 20 years or so. The old common law in terms of bringing actions was that there had to be an action that was actionable both in England and Wales and in the country where it happened. We codified some of our private international law in 1995, and in the context of road traffic accidents and other injuries sustained overseas for which proceedings were brought in England and Wales, the case of Harding and Whelans, which is a 2007 case in the House of Lords as it then was, now been replaced by the Supreme Court, was quite important because it determined that the procedural law would be governed by the law of the forum, but the substantive law would be governed by the place that the injuries were sustained, that is to say the lex loci delicti, as we say in Latin. That meant that in Harding and Whelans that although the heads of damage were governed by the applicable law in the locality where the injuries were sustained, that is to say Australia, the assessment of those heads of damage and the actual loss sustained was to be regarded as procedural law and governed by the law of England and Wales, which in that case, again a case of someone being seriously injured, made a significant difference to the damages that they were ultimately awarded. Rome II is, as I say, Regulation 864/2007. It's applicable to non-contractual obligations, and it's applicable to events occurring on or after the 11th of January 2009. There was at one stage an issue which I'll refer to briefly as to whether it applied from the 11th of January 2009 or in fact applied from the 20th of August or thereabouts 2007, which was 21 days after the publication of the regulation in the official journal, which, as many people who watch this video will realise, is the day when regulations are ordinarily deemed to come into effect. But going on to what our Rome II covers, I'm not going to try and deal with every last paragraph of Rome II in this presentation, which I intend to last something of the order of 15 to 20 minutes. But I am going to deal with some of the more material aspects. They will, as I indicated as I started, have a slant towards those cases where the issue deals with liability and quantum in relation to injuries sustained by someone in a jurisdiction other than the jurisdiction of their domicile. Article 15 is perhaps one of the most important articles of Rome II, and I'm not going to read it out again. I think it would help for those who are going to watch this video to have it available. But Article 15 deals with the scope of the law applicable. And it's plain from Article 15 that it will deal with the basis and extent of liability. It'll deal with the grounds for exemption from liability, any limitation of liability, and the division of liability between two or more people or bodies that were responsible for the same tortious act to a greater or lesser or in fact equal extent. It also deals with the existence, nature and assessment of damage or the remedy claimed. So that's the Harding and Whelan's procedural rules gone. Within the limits of powers conferred by the court, it also deals with the measures which a court may take to prevent or terminate injury or damage, and other matters such as whether a right to claim damages or a remedy can be transferred, including by inheritance, liability for the acts of others, persons entitled to compensation for damage personally, and the manner in which an obligation may be extinguished, that is to say the rules of prescription and limitation. And each of those separate matters is of course quite important in the context of considering tortious liability. This has to be regarded as the new roadmap and the definitive roadmap for actions involving tortious liability brought within member states of the European Union. Something it doesn't cover the rules of evidence, and it doesn't cover procedure, but as I say, for instance, the rule in Harding and Whelan's categorising the assessment of damages as procedural is gone. But the burden and standard of proof, which may be important, is still now governed by the applicable law. Well, let's just consider, if we may, what law will generally apply in relation to what we may describe for a moment as cross-border torts. The law which applies is dealt with by Article 4, and as you'll see, I'm leafing through the regulation as I speak to you. And unless otherwise provided for, Clause 1 of Article 4 provides that the rules and the law applicable to a non-contractual obligation arising out of a tort or a delict shall be the law of the country in which the damage occurs. That's irrespective of the country in which the event giving rise to the damage occurred, and irrespective of the country or countries in which the indirect consequences of that event occur. So the fact that someone who's seriously injured in Spain in fact has to incur lots of costs in England and Wales doesn't mean that the law of England and Wales will prevail. It will be the law of Spain, subject to what I say after. Article 2, however, provides that where the person claimed to be liable and the person sustaining damage both have their habitual residence in the same country at the time when the damage occurs, then the law of that country will apply. So, for instance, if a married couple or two partners or two friends for that matter are on holiday in a country other than that where they live, and because of the negligent driving of one, the other is injured, then in fact when an action is brought in the country where they both live, it is likely that the law of their habitual residence will apply. And again, this may be material and an important distinction to bear in mind. There's also an escape clause which provides that where it's clear from all the circumstances of the case that the tort is manifestly more closely connected with a country other than that indicated in paragraphs 1 or 2, then that other country's law shall apply. And this clause says that a manifestly closer connection with another country might be based in particular on a pre-existing relationship between the parties, such as a contract that is closely connected with the tort or delict in question. So perhaps it's possible that if an employer employs someone in England and Wales, but they are not in fact domiciled in England and Wales, and thereafter somewhere else in the world or in the European Union that employee is injured as a result of a breach by his employer of the contractual duty to maintain a safe system and safe place of work, then it seems to me to be arguable that the English law, or the law of England and Wales, to put it more correctly, may well apply to that claim. But these are early days, and we don't know exactly how the courts and ultimately the European Court of Justice will interpret all the various clauses and articles contained within this regulation. There was, as I mentioned before, arguable temporal issues that were regarded as being important prior to the decision of the European Court of Justice in Homewu on the 17th of November 2011. That arose because Article 31 and 32 were apparently somewhat contradictory, certainly to many people's eyes. I needn't deal with this in detail, but it's suffice to say that Article 31 says that the regulation shall apply to events giving rise to damage which occur after its entry into force. Article 32 said the regulation shall apply from the 11th of January 2009. Many of those watching this will know that the European law generally applying to quotes, entry into force, close quotes, is that a regulation enters into force 21 days after its publication in the official journal, which in this case will be the 20th of August 2007. There was an obvious tension between that and the 11th of January 2009, and a number of cases, certainly in England and Wales, including Bacon and Nacional, Suiza, and also Homewu itself, had to deal with this issue. The matter was resolved by the court on the 17th of November 2011. That's really of no great import now, except to say that it's plain that the regulation applies to events that occur on or after the 11th of January 2009. So what's the impact of this regulation? Well, the impact is that unless you're habitual resident in the same country, that is, the person who's affected by the tort and the person who caused the tort and is liable for damage arising out of it, then, unless the escape clause applies, the law of the country where the damage occurs will govern liability and the assessment of quantum, the amount of damages. It includes the heads of damage that would be awarded. So, for instance, in road traffic accidents, it will deal with what heads can be awarded, such as loss of earnings, loss of future care that's required, the loss that's occasioned by that, the losses that are occasioned by the need to have specialist accommodation. These are matters which are very substantial, and not untypically in England and Wales, for a serious injury, the damages assessed under these heads of loss overall can amount to many millions of pounds. And then there's a slight odd twist to the regulation, because at Preamble 33 in the recitals, recital 33 I suppose, it says this: according to the current national rules on compensation awarded to victims of road traffic accidents, when quantifying damages for personal injury in cases for which the accident takes place in a state other than that of the habitual residence of the victim, the court seized should take into account all the relevant actual circumstances of the specific victim, including in particular the actual losses and costs of aftercare and medical attention. That seems to acknowledge the reality that the system of assessing compensation for serious injuries occasioned both in road traffic accidents and in other kinds of accidents differs markedly from state to state, and the amount of damages awarded may be very much diminished if the law, for instance, of Spain is applied as opposed to the law of England and Wales. However, it's difficult to see how that squares with the terms of the regulation itself, and particularly with the terms of Article 15. There's quite a lot of academic commentary on this, and some say it reflects the tension that there was in the Parliament as this went through, and the regulation again itself recognises in its closing statements that the Commission is aware of different practices as regards the level of compensation awarded to victims of road traffic accidents, and is prepared to examine the specific problems resulting for EU residents involved in road traffic accidents in a member state other than the member state than of their habitual residence. And the problem can be stated very simply this: if you are injured in Spain but you have to meet your costs in England and Wales, it may be very difficult to meet those costs if they're assessed according to a system of law and a system of procedural law which calculates them in a wholly different way to that in which they're going to be expended. This will remain a problem, and no obvious solution has arisen yet. So back to recital 33. Will it provide scope, for instance, for courts in England and Wales to adopt a more liberal approach to the assessment of damages for future care, for instance, which in some of my cases may amount to 3, 4 or more £1 million? Well, we await the results of the cases that will pass through the courts. Certainly from a claimant's point of view, one will argue that it does allow the court to have flexibility in the way in which it interprets Article 15 and applies the regulation as a whole. No doubt defendants will say that you can't negate the obligations imposed by the specific articles. And it may be that there will be negotiation between the parties, since neither may necessarily want to test the first, that they'll be the first to test this aspect of things. It's quite an important matter. Now, there are other aspects of the regulation that you should be aware of. As I say, this is of universal application, so Article 3 provides that any law specified by this regulation shall be applied whether or not it is the law of a member state, so that someone injured outside the European Union who chooses to bring action and is able to bring an action in the European Union or in the courts of a member state of the European Union may find that the law of the foreign country in which they were injured or affected will apply. And that's one of the matters that, again, will no doubt become the subject of litigation and interpretation as we go through. There are a number of other aspects of the regulation, but this was, as I say, intended to be a 15 to 20 minute talk, and I'm not going to try and deal with all the other possibilities that arise as a result of it. Insofar as this is a video that will be viewed by those who have to handle things like road traffic accidents overseas, I just want to add a few words of advice, if I may. The fact that someone is injured overseas and your client had the accident at some distance from you doesn't mean that you shouldn't investigate it in the same way that you would if it was in your own locality. So in terms of this situation, if you are going to proceed in the country of domicile of the person injured, perhaps relying on the decision in Odenbright that enables you to sue the insurer direct, then of course there are advantages to the claimant of not having to deal with foreign litigators, but you need to remember that this again, if it's a road traffic accident that's given rise to serious injury, is like any other serious road traffic accident insofar as it needs investigation. The fact that it may be a little further away from your office and a little more awkward to organise doesn't matter. The issues are still important, and it will be necessary to preserve the motor car, for instance, to obtain reconstruction evidence in relation to the accident, and it's the more important that things are done sooner rather than later when you are dealing with accidents abroad. But that perhaps would give scope for another seminar in itself. I hope that this has been an introduction and perhaps some food for thought for those of you who have to deal with talks on a cross-border basis with any regularity. And as I say, that's the scope of the talk that I wanted to give you today. It's been a pleasure doing this for the European Civil Law Observatory. I hope it'll be the first of a number of videos that I assist with. I've developed a keen interest in comparative law, and actually the reality is that everyone in every field of law needs to understand that this is a global world in which we operate, and the comparative law and the conflicts of law that sometimes have seemed a bit distant for some of us is something we all need to know about. Thank you for listening.